Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, how is everybody? Did everybody hit the thumbs up? Hi, Tammie. Hi, Markar. Lisa. Lisa. Nice to see everybody. Wanted to talk ahead of the hearing tomorrow about Karen Read and what continues to be an innocence fraud campaign done in an unusual way pre-trial by the defense, and the lack of response from the public, the other lawyers, the press. We're watching fraud happen in real time, and few people are really calling it what it is it's a giant fraud upon the court and the public that the defense has done in saying that, presenting the ARCA witnesses, Rentschler and Wolf, as independent, unbiased witnesses. They weren't. They were paid, retained, paid. And of course, there are intertwined with the federal investigation, but they certainly weren't independent, and they were only given a limited bit of information. Does anybody remember Daniel Wolf's testimony where he said, he was asked, where did you get your information? And he said, well, from the federal and the feds. But we know it came from the defense. And he also said in cross that he didn't think his investigation would change if he got more information. So he knew these weren't unbiased witnesses, but we had a hunch that something was odd with their conclusions and that they only wanted to use a limited bit of information. But we still don't know the full extent of the relationship between ARCA and the defense. And I often talk about Judge Cannone allowing this to happen, allowing this fraud to happen, and by allowing the fraud to go on under her nose, we all saw how skeptical she was when she asked, you mean you're showing three witnesses that you've never talked to? And of course she says, and of course they say, oh, that's what we're saying, essentially. And curiously, I miss this moment. I think basically Alessi just numbed my brain the other day. But I wanted to show you a great thing that Innocence Fraud Watch put together about Hank Alessi. Hold on 1 minute. I might have to take a break. I thought I pulled this up, but I may not have. My apologies, guys. Hold on 1 minute. where you see in this clip Alessi saying, here we go. I have it. Okay. Hold on. You see Alessi basically saying, you know how it is, Your Honor. You know, I know you get it. What does he think she gets? And look how dishonest this is. Just take I'm going to share my screen in a second. I was just skipping past the ads. The volume is a little low. I'm just going to make sure I have it up all the way, every way. Okay. On this clip. But Alessi, as he screams, you'll hear him loud and clear. So take a listen at this. So it starts with Hank Brennan.
I won't repeat it, but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember.
So now I almost want to whisper because it's so low. He says there's a murky relationship that we haven't even scratched the surface of. Boy, is that not the truth. Or it is the truth. Wait, did I just do a double negative? Boy, if that's not the truth. There I go.
Remember that the defense noticed 3 experts, including Mr. Klein. When we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCA, this is June 10, 2024, trial transcript 28.
Hold on one second. Let me grab that.
Okay. I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when you look at the ARCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continue questioning, you were told, well, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for the purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from the report who did what. They noticed 3 experts. So there must be conversations with somebody explaining the witness's role or why only 2 of those 3 witnesses are important for the defense.
Attorney Brennan talked about 3 witnesses, right? And he said he was, I believe I took it as clearly inferring 3 ARCA. Your Honor can go back to the transcript. It was Dr. Russell was the 3rd one.
Oh, I thought it was the 3 ARCA people. I will go back to the transcript.
You can go back to the transcript early.
But later the judge says, well, no, I was talking about the ARCA witnesses. So what Hank Brennan said, if you missed it, I'm sorry about the low volume, is that you couldn't tell from the report who did what. How did they know from this report that's so vague whose testimony, who did what in the investigation and who would be useful to their case? They couldn't have known without talking to them.
Earlier on, there was a discussion way early on.
Who is Mr. Klein?
He was a 3rd ARCA expert that was involved for the government, right? And then he stopped, and we didn't retain him for testimony.
Okay.
Let me be clear on what I mean by retain. He didn't testify.
It's been a long day.
I'm trying to answer your question.
I know, and I realize that you just said something that you want to explain. Go ahead and explain what you
So
just
what I'm
said.
saying is, in terms of, I'm going to take back the retain. The point is, there were originally 3 ARCA persons on the report that we got from the government, right? Rentschler, Wolf, and Klein. We only went forward with the testimony of Rentschler and Wolf. And that's what I want to come to, Your Honor. The whole emphasis was that the Commonwealth had no notice that we were going to use these experts. Your Honor, the voir dire was the notice. And my point was, I didn't say that there was no bias. What I said was, once you decide you're going to use an expert, right, you're going to be having them testify.
I didn't say there was any bias, but Alan Jackson told the jury and the judge repeatedly, and the public, let's not forget the public and the press, that these were unpaid expert witnesses, and they told the court that they couldn't talk to them. They were barred. So where is the investigation into the defense talking to federal witnesses that they weren't supposed to talk to? Where's that? I mean, is this like the Wild West? We're looking at the Wild West. They can lie to the court as much as they want. And now they say they're not being paid. So what punishment is it to have them thrown off the case? It's a punishment to Karen Reed. But these lawyers should be disbarred. End of story. And Alessi, may I note, signed the filing, of 216, where they said these are totally independent, unpaid witnesses, and they talked about how they were acting in good faith in that filing. Meaning, we're acting in the best honor, most honorable, honest way possible, and they accused the Commonwealth of dishonesty. My head is going to explode from this fraud. I can't take it. This is how innocence fraud works. It's a failing on, so it's not just fraudulent lawyers. It's the judges that let it go on. It's our press that doesn't call it out for whatever reason, whether they're ideologically aligned and think that the accused is always the little guy up against the state, or the convicted that we shouldn't punish anyone, and they have other issues with our criminal justice system. They let it happen. The press lets it happen. And the overworked, overburdened public cannot get out on the street and protest. But this is much more applicable to our citizens' daily lives, and that when our justice system breaks down, this is what holds together a civilized society. And when this breaks down, we have a breakdown of society. And this goes on and on in case after case. So if you had followed, I started out my channel talking about the Adnan Syed case. And we didn't know which way. So it's a complicated situation. But basically, there was a fund of money by the Open Society Foundation, about a little less than $50 million, given to promote all these former defense attorneys run for district attorney. So meaning when they got in, they would do the bidding of the Open Society Foundation, and also through the ACLU was involved. It's often called Soros prosecutors. So the Open Society Foundation is Soros's foundation, or soft on crime prosecutors. So one of them was Marilyn Mosby, who was in Baltimore. He was overseeing the Adnan Syed case. She was facing fraud charges of her own and let out Adnan Syed on a bunch of ridiculous evidence. One of the pieces of new discovered evidence was a witness describing Adnan Syed harassing the victim, Heyman Lee, before he was released. So anyway, there was just a 80-something page filing discussing the fraud upon the court that just let Adnan Syed out. It's too late for Marilyn Mosby. She was convicted of fraud, ultimately. But will there be an investigation into that? Will heads roll? Probably not. And so when there's little punishment, it just allows everyone else to keep doing it. And you can see with the amount of support online by lawyers saying that it's really the Commonwealth that is in the wrong somehow for something, and that really the defense didn't do anything wrong, and covering. How probably what I gather from that is how many lawyers are involved in this fraud and act in these same kind of ways and do this same kind of tricks, like hiding discovery. This is what this is all about, is hiding discovery. So Cannone said she remembers that she was talking about the 3 ARCA witnesses. He says, oh no, you were talking about Dr. Russell. It doesn't matter. Dr. Russell was another witness that they handed over no discovery for, because this was their technique with their witnesses. Just sort of hide the discovery, and then for punishment, we get a voir dire, and we get to control the questions asked. And the Commonwealth, in cross-examination, doesn't know the questions to ask because they've just been presented with a lot of information in a very short period of time. Great.
Anybody could claim that testimony is biased. But the point is, Your Honor, that the allegation that somehow mysteriously this third person that was being discussed, and clearly the inference was that we were misrepresenting still about which ARCA witnesses, because we weren't talking about the third. The third was Dr. Russell, and you'll see that in the transcript.
Okay, but when I said you expect something, whatever I said, you expect me to believe that you are calling 3 witnesses whom you've never spoken to. When I had that discussion with Ms. Giannetti, that's who I meant.
Thank you for bringing that up, Your Honor. And that was just ARCA. That was nothing to do with Dr. Russell. But here's the important part. Attorney Brennan didn't read the rest of it. You're to believe.
So where are we? Are we the June 10th, Ms. Giannetti?
Your Honor, June 10th. That's exactly right. That's exactly right. Was June 10th. It's important. He stopped.
So it's page 12.
Yes, thank you. So on June 10th, so you're to believe, this is line 19. So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. Here's the response in its total. That's essentially it. We've spoken to them. So it's not like it wasn't disclosed there was a conversation. It was. We've spoken to them only for the purposes of coordination of their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports. Your Honor, that's 100% true.
You read that earlier.
Right, but
He's like, we weren't hiding we just said that the conversation that was much more in depth about the testimony that we had. Your voir dire was terrific. Here, don't ask me about this. Don't ask me about that. We just don't know. We didn't hide that there was conversations. We just hid the relationship. Don't you get it, Your Honor? So ridiculous. I mean, and these lawyers get a kick out of it. I don't know if basically arguing, trying to get people to believe lies. I mean, you know what I mean? Trying to make the lie a truth. What a powerful thing to feel. Get everyone to believe a lie. What power you must feel.
Mr. Brennan just missed the truth. He made it seem like that was an untruthful statement, and I know Your Honor gets it.
I know Your Honor gets it. So does that mean I know Your Honor gets it? Because Hold on a sec. Does that mean Your Honor gets it because she was a former defense attorney who did the same kind of tricks? Is that what he means? I know Your Honor gets it because you've turned a blind eye on all the other things that have gone on in the court. I mean, here's another reminder of something else that Judge Cannone has turned a blind eye to. I mean, that's the theme for today. How many things she's turned a blind eye to in this case that she could have called out and put a stop to? Okay, here we go. Here's Elizabeth Little showing a exhibit that she shouldn't show.
So, Ms. Little, I'm not looking at any, if you show them to the audience before you show them to me, I'm not going to look at them. Okay, please put that down. Mr. Yannetti, do you have chalks for your bail? Please.
Look at Elizabeth Little showing it right to the cameras, making sure the cameras get it, because these hearings, and they still aren't just about talking to the judge and the court. They're talking to the public and the press, and they get it. Look at Elizabeth Little facing the camera directly. She knows she's not supposed to show it. She has to make sure the camera gets a keen eye of it.
Please put that down. Do you have chalk?
Please put that down. What an admonishment for this kind of abuse of the court.
For your bail argument?
Do you have exhibits for your bail argument? Not what? When you know, there's some judges that I've seen rule their court that never have to raise their voice, that you wouldn't dare cross. But Judge Cannone has let it be known that you can act any which way in court, roll your eyes. I think she once admonished Karen Reed, laugh, flick your hair, mug for the camera if you're Karen Reed, and you're not going to get in trouble. She set the tone. The judge sets the tone. So I wanted to also show Vinnie Politan was a big Karen Reed supporter in the early days. Here's a clip from Twitter on Melanie Little's show. Boy, has he changed his tune.
She was drinking. He was drinking. They found him the next day. That's what we're going to prove. Thank you.
It's a simple case, right? And that was the other thing I would do as a prosecutor, and it's kind of translated into my work on television, is you have to take whatever you think is this complicated, layered thing, and you've got to make it simple for the jury. And Lally made everything, even simple questions, he made very complicated. I don't know why. But the prosecution case, you're right, is a very simple case. And the way it should be tried, and should have been tried, was Karen Reed was drinking. Karen Reed was behind the wheel. Karen Reed was in front of the house. John O'Keefe got out of there, and Karen Reed drove off and hit him. And when she returned the next day, she was telling people that she hit him, right? And you're right, it's about the rebuttal case. If the defense...
Don't you remember the days when he said that was such a complicated case of corruption and he thought the Commonwealth had it wrong? What happened?
Then goes out there and tries to prove something else, or something else comes up during the defense case, then you have your rebuttal case to rebut all of that and get back to the core of your case. I think both sides, I did not, and I know there were some limitations on what they could do at trial, but I didn't feel like prosecutors proved that first count beyond a reasonable doubt. But I don't think that, and I kind of landed where the jury seemingly landed, kind of stuck on count 2. And I don't think the defense proved the conspiracy. And I don't know if you could.
What? Boy, that certainly wasn't your attitude last month. What happened?
if you inverted this case and made Alan Jackson the prosecutor of everyone in that house, right? Could he prove that case beyond a reasonable doubt? I don't think so.
She was drinking.
Okay, there we go. Boy, times have changed. Things have changed. Now it's a simple case, and it's all Lally's fault. Lally, the overworked. You know, I don't think he did a great opening statement or closing statement, but I'm not like blaming on Lally. Most lawyers are not TV ready. You know, they're not entertainers. They're lawyers. And I think that had we had a fair jury, I think we would have gotten a conviction on the second degree murder charge. I don't know, but I certainly feel it was proved that this is I don't know. I don't understand the reticence. How could she ignore her infotainment system beeping and flashing at her? She knew she hit something before anyone else did. And she left him to die. So I don't think it was an accident. I think when it's an accident, you get out and check. And if I were a juror, which I'm not, so I don't have to hold a position of innocence until deliberation. I can have an opinion. I would be arguing till it was blue in the face that this was second degree. I don't think but even on people on this side of the fence, I mean, I don't even think we've been called anti-Karen, but I think it's a much more complicated situation for those of us who really feel strongly that Karen Read did this out of anger and spite and meant to, as she says, she describes it. The aim was to teach John a lesson, right? She meant to hurt him seriously, and it caused death. So there's your second degree charge. But, of the people who are like, well, Karen Read is guilty of something, maybe some small little charge. I don't know. I don't feel simpatico with them. I don't really understand their thinking, and it hasn't really been explained. And that's not really explaining your position, saying, well, I wasn't convinced. Well, why weren't you convinced? And I notice more and more I get comments that, in the beginning, when I first started covering Karen Read, there was a lot of comments. You don't understand ARCA. You're ignoring maybe the ARCA experts, because that's the best thing that they had. They have to know that was the best thing they had. We all knew that investigation was tainted by Karen Read and her family and was meant to make it look like something nefarious was going on when it wasn't, which is all frauds are making something look like something it's not. So make it look like there was something really there to investigate when they came up with nothing. But okay. I mean, the Karen Readers still won't admit that's over. But if you've been convinced, brainwashed by the Free Karen Read innocence fraud campaign, you might think that ARCA are honorable, reputable guys, right? With no connection to the defense. So Elizabeth Little, I just want to go over this really quickly. I think this is interesting. We may see this tomorrow. Is now saying it's all her fault that in the 216 filing that every single person signed. So you're going to tell me that a lawyer wouldn't say, oh no, we're misrepresenting this. I can't sign this. You think a lawyer is going to be sloppy about what they sign and sloppy with words? They're all wordsmiths. Says, I, Elizabeth Little, do hereby depose that the facts set forth in the certification regarding defendant Karen Read's opposition to the Commonwealth's motion to exclude employees of ARCA filed herewithin are true and correct to the best of my knowledge, information, and belief. The statement called into question by Special Prosecutor Brennan at the last hearing was poorly worded. It was poorly worded by a lawyer. We all misunderstood because it was poorly worded and should have reflected more specifically that the defense did not hire, retain, or pay ARCA to engage in the reconstruction analysis and or testing was performed by ARCA in connection with this case. I personally edited and was responsible for the filing the opposition. So now they're just doubling down on this idea that they were retained, but only after the federal investigation and only paid after their testimony. I mean, I don't think this is going to fly, but you never know with Judge Cannone, which way she's going to rule with it. I'm going to take a quick break and I will be back in 1 minute. Don't go anywhere. We're going to go back in time when we come back. Go to an early hearing and bring up a early character in this case that we haven't seen. Stay tuned.
We don't take a break. Grab a snack or maybe a glass of wine. Roberta will be back in no time. This podcast is listener supported, so smash that like button and subscribe or become a patron for exclusive content if you are so inclined. Have something to say, shoot Roberta a super chat. She will do her best to read it all air without delay. Now Roberta's back and ready to put the true back in true crime. Here's Roberta.
Okay, we're back. So I just wanted to show you on this. I mean, the theme for today is all the fraud that's gone on in the court that hasn't been called out. Here's another great one. Her attorneys say if she hit him, she did not realize it. Do you remember this from May 6, 2022? Is that right?
Attorneys say that if she hit him, she did not realize it. Reed has been out of jail since February after attorneys say that if she hit him, she did not realize it.
Okay. Curious, right? Very curious. Unreal, right? Unreal. But let's go back to a character that we haven't heard from. Also, does anybody remember when Karen Reed breached her bail conditions? So when they went to get her phone, they realized Tully said that her phone was on its way to the to the area of the airport, and then they clocked it going all the way to Sarasota. Strangely, where Tanis Yannetti, here's this character we haven't heard from or haven't seen in a while. And I want to share this early hearing because it's just so ironic in retrospect. Here's the Karen Reed hearing from March. This was 4 days after Yannetti first spoke to ARCA. And you'll see Tanis Yannetti says she strategically filing her motion. And she's also accusing the Commonwealth of not handing over a proper discovery. Oh, the irony. So this is, if you don't know who Tanis Yannetti is, she's David Yannetti's sister. This is Ian Henchley, who's also at the law firm, started working at the law firm when he's in college, is now partner at the Yannetti law firm. So when they wanted to get Karen Reed's phone, it was on its way to Sarasota. They watched the phone go to Sarasota, Florida. So you would think, I don't know, I can't prove this, but you would think that someone like David Yannetti or Tanis Yannetti got word that they were coming for Karen Reed's phone and told her to hop on a plane. Because when they did come for her phone, second time, Karen Reed kept them out of the house for 45 minutes and would not let them in till her dad arrived. So, again, does this ever get back to Judge Cannone? Any of this behavior? Curious about that.
Draw near, give your attendance, you shall be here, heard. God save the Commonwealth of Massachusetts. This court shall open.
And in Karen Reed's bail conditions, she's not supposed to go anywhere near the witnesses or the victims. And one of them sees her driving by the house with David Yannetti and with Alan Jackson, in the car. What happened? What happened with that? And this is all in the discovery in Aidan Carney's case. So here it is. September 17, 2023, Sergeant Buchanan was notified by Mark Grossman, who lives at blah, blah, blah in Canton, redacted, that Karen Reed was in a vehicle in the area of One Meadows Avenue, Canton, on Sunday morning. One Meadows is the current residence of the decedent John O'Keefe's juvenile niece, nephew, and his parents. Mark also sent a picture and a ring video of the vehicle that Karen was riding in. Please see Sergeant Buchanan's report. The vehicle, a black Yukon, was bearing this license plate. It is known to this office that as a part of Karen Reed's pretrial conditions, she has a stay-away order from the victim's family and residence. On Wednesday, September 20th, we identified the registered owner of the vehicle involved as Melvin Moretta of Sevo, and at approximately Trooper Prox and I traveled to the residence in Providence to interview him about the vehicle and who was driving his vehicle. We met Melvin and a female resident named Elena at the door, and we were invited into his living room for the interview. Melvin stated that he knows Karen and her lawyer, Alan. He said that he had transported them both on 2 different occasions to and from court at Norfolk Superior Court in Denham. Both occasions, Melvin picked them up at the Omni Hotel in Boston and dropped them off at the same location. Were they sharing a room at the Omni? I don't know. Melvin said that on Saturday and Sunday, September 16th and 17th, his co-worker, Roman Martinez, drove his vehicle and worked for Karen and Alan. Melvin called Roman on his cell phone and explained to him that we had some questions about his travel over the weekend. Roman's three-way called his wife, Bianca Vargas, to help translate our questions and answers. Roman said he picked up Karen Allen and a blonde woman who he believed to be Karen's attorney, and another woman he called a witness. He picked up all 4 occupants at the Omni Hotel in Boston at 4 p.m. on Saturday, September 18th, 2023, and dropped them all off back at the Omni at 10 p.m. On Sunday, September 17th, 2023, he picked up all 4 occupants again at the hotel. At the Omni in Boston at 7 a.m. Roman said that when he got into the car, Karen wrote down the address 1 Meadows Avenue, Canton, for Roman to put into his GPS. Okay. Roman said that when he arrived at the area of 1 Meadows Avenue, they asked him to park far away from the house and to wait there. Roman said that Alan, the other woman described as a witness, exited the vehicle and started to walk around the area. So why does she still have her bail intact? Why hasn't it been revoked? He said Karen and the blonde attorney stayed in the vehicle. Roman said that Alan and the other woman described as a witness exited the vehicle and were gone for less than a minute. Roman said he became uncomfortable because he saw someone taking pictures of his vehicle. Well, good looking out. You were right, Roman. So, kind of amazing, no? I mean, how much of this nonsense has gone on in this case?
Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record, starting with the Commonwealth?
I'm Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Mr. McLaughlin. Good morning, Ms. Yannetti.
And good morning, Your Honor. Ian Henty on behalf of Karen Reed. Attorney Jackson should be with us on this.
Okay. Good morning, Mr. Henchy. Good morning, Mr. Jackson. And good morning, Ms. Reed. All right. So in court are counsel who will argue the motions for today. And there's only Mr. Henchy and Ms. Yannetti. When I set dates on the modified scheduling order, I set dates that were convenient to the parties in recognition of mainly defense counsel's trial schedule. And last week I renewed the Pro Hoc Vici motion, but I see Mr. Jackson chose not to be here today, and so counsel will argue the motion here this morning. So, but before we begin, I have been told repeatedly from both Mr. Jackson and Mr. Yannetti, and I do understand completely that Mr. Yannetti cannot be here today. He's certainly excused from being here today. But I was told that there would be a motion for a motion to dismiss based on egregious government misconduct. I was told that by both Mr. Jackson and Mr. Yannetti. I asked Mr. Yannetti how that motion to dismiss was any different than the motion for sanctions and motion to disqualify the district attorney's office.
So this is similar to what they just filed. Their big motion to dismiss. We have a hearing on this week.
He assured me that it was in fact different. He assured me that he would put in the body of the motion how it was different. And he assured me as recently as last week that that motion would be filed later that day. So that motion has not been filed. That motion then is waived. So what we have today are two motions regarding Rule 14 obligations. So who's going to argue? Is it Ms. Yannetti or? I will be arguing. Okay, so I need you at a microphone. So I will hear you on the motion where you're looking for notes, reports, memoranda, and
Right. So Rule 14 has to do with discovery, handing over discovery. They have an obligation to keep things fair, and they're always talking about fairness and corruption. We're watching the corruption go on in Massachusetts, but it's not happening from the Commonwealth side. It's happening from the defense side.
And logs.
Thank you. Your Honor, at the outset, I just want to note that as this court is aware, we have a motion pending before the court to disqualify the Norfolk DA's office.
So my theory on this is that This Yannetti, the female Yannetti, is behind the scenes pushing this forward, protecting Karen Reed, protecting her phone from discovery. And there were rumors that it was factory reset. So, you know, when they finally got it, they got her first phone with her communication, but all the communications between Aidan Carney, she had 2 phones when they finally got them. Who has 2 phones? She doesn't have any business. She can't say it's a business phone at work. She has 2 phones. She thinks like a criminal, and so do her lawyers. And in my opinion, they act like criminals. That's my opinion.
From this case. Our position, therefore, is that the DA's office should not be participating in this case or arguing any motions, including this one. And I raise this issue just to alert the court that we are not waiving any objection to their continued involvement in the case.
Okay, so I haven't decided that because I was waiting for the motion for egregious conduct, motion for sanctions, or motion to dismiss based on egregious governmental misconduct, because I needed to be assured that that was different than the motion to disqualify. If I had known it was not coming, and maybe no intention of filing it, I would have decided that motion by now.
Your Honor, it was a strategic decision
Okay.
for us not to file that motion. It's not because it wasn't meritorious. It was a strategic decision
All
only.
right. You made representations that you were, therefore the other motion, I have not acted on that yet.
I just want you to note the objection, please.
Yeah, the objection's noted, so please move on to the merits of your discovery request.
Absolutely. Your Honor, we're asking for material that fits squarely within the parameters of Rule 14. Statements were made to investigators in this case, including to Mr. Lally and to his staff, and in certain conversations, the state police were even present. Statements of witnesses are simply discoverable. Although they lodged general objections to each of our requests, and these were really boilerplate objections, the Norfolk DA's office appears to be arguing that these witness statements contained in their notes of their conversations, multiple conversations, are all work product. Neither this court nor we are in a position to judge whether the notes are strictly work product without actually seeing the notes. Work product is defined as legal research, opinions, theories, or conclusions. And to be clear, we are not interested in the Norfolk DA's office's opinions, theories, or conclusions. To the extent that these notes contain work product along with the statements, we are fine.
So this is a fishing expedition. Just try to get to hear what the witnesses are saying and find some kind of difference that we can exploit. This was what this was about. See if there's difference between maybe their statements or something, some sort of impropriety that we could exploit.
With the work product being redacted, we are not interested in their work product, but it is important for us to know whether their notes contain any statements of witnesses, and if they do, they should be turned over to us. Otherwise, discoverable material is not off limits simply because a prosecutor writes something in the margins of a document. That would give an attorney the power to keep otherwise discoverable materials out of the hands of a party who should legally be entitled to see the material. At a minimum, Your Honor, this court should order the Norfolk DA's office to disclose whether its notes contain any statements. They have not disclosed that. If the notes contain any witness statements, and if the Norfolk DA's office is objecting to producing them to the defense, then this court...
Then if you're objecting to handing over all these notes that you've taken with the witnesses, then we're just going to have to rely on Karen Reed going through all their personal Facebook pictures, notes, relationships, which we know she did. If you've been following this channel from Wikis, remember her? Remember her? The middle woman? From her I guess it was her statements to police, which I think are a quarter of the truth.
We're asking this court to have the DA's office produce those notes to the court so that this court can conduct an in-camera review of their notes and evaluate whether they are truly all work product or whether there is in fact discoverable material contained therein. Beyond that, Your Honor, we would rest on our motion in our brief.
Okay, thank you.
Thank you.
Mr. Lally, your response, please.
Yes, sir.
And Your Honor, I'll be brief. So essentially what the defendant's motion seeks is, and I would object to the mischaracterization of every single phone call or conversation with a witness as an interview with a witness, but I'm not even sure what half of these are referring to, as I don't recall any of those specific meetings occurring. But if there were meetings, any meeting with a witness post-grand jury was in reference to either harassment that they were sustaining as a result of actions of others in this case, or as a result of a simple explanation as to Rule 17 motions that have been filed for individuals' phones or phone records or other third-party records that they were the subject of. It's a boilerplate response because it's a boilerplate law that applies in this case as far as work product that applies to each and every one of the requests, with the exception of number 8, of which the Commonwealth has no objection to that.
Explain to me how work product applies.
Your Honor, work product applies and specifically in reference to, it's contained within, and I would largely rest on the Commonwealth's motion, but it's contained within what's cited as Beng Sia Lang in regard to interview notes in preparation of testimony is work product under the case law, under the rule of criminal procedure. Whatever notations may be contained within those. But essentially, these are not statements as are defined under Rule 14 from any of these conversations with witnesses. Rule 14 doesn't apply to these statements, number one. But secondly, if there is any content, it's either already been provided through the course of discovery, whether it be contained within a police report, grand jury minutes. There's nothing different than what has already been provided. And then secondly, what the case law states and what Rule 14 states is that
Does everybody get what's going on here? They're accusing the Commonwealth of gross misconduct. Gross misconduct in the case for not handing over these statements, all the witness statements that have already been handed over, but are not applicable. Any communication the Commonwealth has had, like, hey, can you come down here Tuesday? Has to be handed over. They say they need everything. So they're essentially accusing the Commonwealth of hiding their relationship with their witnesses. Exactly what was done in this case by the defense. Exactly. The irony is too great.
These types of conversations with witnesses, whether reduced to writing or not, are within the ambit of the work product doctrine.
All right. Any response? You don't necessarily have to, but I just want to see if you want to.
I would just say, Your Honor, their opposition to our motion does not even acknowledge whether there are statements or not statements. I just heard Mr. Lally say that there in fact are statements. So I am going to ask again that this court take those notes there and go through it and in camera and decide whether in fact all of it is work product or whether there exists within it discoverable materials with statements of witnesses. And I find it hard to believe that there wouldn't be any statements of witnesses concerning this case. Thank you.
Do you want to respond at all?
Your Honor, again, with reference to
Just to give you a picture, just remember that 4 days before this, David Yannetti was talking to ARCA.
Term them interviews, but essentially phone calls with witnesses. These were in regard to explaining to them the Rule 17 process, explaining to them what counsel had filed, what types of records were being requested. It was in large part me talking as far as explaining the law and things of that nature. There were not any statements related to the case or any testimony that was discussed or anything of that nature. The one thing that I was referring to is there is one request that does deal with a meeting which involves preparation of a witness for grand jury. And
wouldn't that be nice for the Commonwealth to have how the ARCA witnesses were prepared? Right now, we just have a skeleton. Just as Hank Brennan has said, the tip of the iceberg. And they're incredulous, accusing the Commonwealth of acting in bad faith all along. Projection is off the charts.
Whatever that witness indicated in the course of that was testified to before the grand jury, and it's contained within the minutes and contained within police reports of interviews with that same witness. So there's nothing to report.
All right. All right, the next motion is the Commonwealth's motion for reciprocal discovery. But before we begin with that, Mr. Lally, could you tell me what reciprocal discovery has been provided to the Commonwealth at this point?
Nothing. Absolutely nothing.
Wow, that's a surprise. Is Yanis Yannetti going to get up and say, Your Honor, it was strategic? That's our favorite trick, to not hand over discovery? Please punish us with a voir dire? They had to move the trial. Delay the trial. This time. I mean, zero, none, nothing handed over. I believe this was like 3 weeks before trial, their first original trial date.
All right, so trial is 3 weeks from today. When did the Commonwealth provide its certificate?
So the Commonwealth is unable to file its certificate of compliance at this point. The one, I would say, sort of primary piece that we're waiting on is there were 2 rounds of DNA testing that were done at the Bodie Lab in Virginia. One of those was completed. That was in regard to the defendant's taillight. That was finished, I think, first week of March, and counsel already has all of that. The second piece is in relation to the hair from the rear of the defendant's vehicle. Just for sort of review purposes, that was something that had gone or undergone sort of typical DNA testing, which is autosomal DNA testing, which is taking the profile from, or attempting to take the profile from the nucleus of the cell, and it relates to essentially both biological parents. That sample was of insufficient quality or quantity to generate a sample under the autosomal. So we had asked, and the court had ordered, for the mitochondrial DNA testing, which goes to the maternal side only. And the Bodie Lab is able to do that. My latest update from that, and I say all that just to build up as to a sort of caveat as far as the testing is concerned. So the initial estimate as far as the testing was would put us several weeks out. We had asked that it be expedited. We had paid for it to be expedited. And the quickest that they can turn around a report would be sometime in mid-April. The caveat to that is whether or not there is a sufficient quantity and quality for them to generate a mitochondrial DNA profile from the sample. That I should have an answer to, I was told, by the end of the month. So hopefully by either the end of this week or very early next week, because obviously if they aren't able to generate a mitochondrial DNA profile from the sample, then there's no reason to generate one from the victim and do a comparison. So that would sort of end it there, and then we would then be able to file the certificate of compliance.
All right. Every other aspect of the case, though?
Every other aspect of the case, as I mentioned, there was number 8 in the defendant's motion to compel that we should have to them by the end of this week, if not earlier. So every other.
So I just curious, I've just noticed that her Judge Cannone's heavy breathing, we don't hear that too much anymore. She used to do that a lot through the trial and early hearings. But by the end of the trial, not so much.
Aspect of the case.
But so curious that this has been going on. This is a pattern. I show this to you to show that this is a pattern that's been going on since the beginning. Not handing over discovery.
As far as discovery goes, should be done from the Commonwealth's perspective. And that's the reason that I filed the motion, Your Honor, at this time, understanding that they're not obligated under the rules of criminal procedure to provide anything, but given that we have an April 16th trial date and I have nothing as far as any sort of reports or notice of experts or testing or anything really at all, I'd appreciate being able to get that, review that, or at least see it, prior to the day we're impaneling.
Right. What do you say, counsel?
Your Honor, as you know, we do not owe them any reciprocal discovery until they file a certificate of compliance, which has not been done. I mean, we have received hundreds of pages of documents. I mean, 4 days ago, we received like 400 pages of documents we haven't gone through. Counsel just handed us a thumb drive with, I don't know what's on this thumb drive. We have to go through that. So we haven't given any reciprocal discovery because we are not obligated to do so.
Do you intend to call experts
Yes.
in areas other than DNA?
I'm going to have to defer to Mr. Jackson, who is on Zoom.
All right, but counsel to arguing these motions with.
Just so you know, so just remember what Hank Brennan said, that on any email, if he ever forgot anyone on Karen Reed's rather large team of lawyers, it always reminds me of Jaws. We're going to need a bigger table. We're going to need a bigger boat like Jaws. We're going to need a bigger table to fit all these lawyers. That if he leaves one person out on an email, he gets immediately reminded to tag someone in on an email, meaning the other lawyer that he forgot. I mean, you're going to tell me that Yanis Yannetti didn't know, Ian Henchley didn't know, and at this hearing that David Yannetti had talked to the ARCA person 4 days before?
Was to be present here in court today. Right.
Your Honor, if I can be here for just a second on that issue, Mr. Lally made it very clear that given the fact that he was not in compliance with his discovery obligations, that this motion was not to be heard today. So this is sort of coming out of nowhere.
No, hold on. So Mr. Lally doesn't decide what motions were to be argued. Today was for all non-evidentiary pretrial motions were to be argued. This was filed timely. This was on for today. If you feel that you cannot argue it, that's a different story.
Okay, so he's trying to get out of it. Like, they haven't, because of this delay in getting the DNA results back, so they can't file a notice of compliance, I believe it's called. That means that the defense doesn't have to hand over anything, so they're all in the clear. They're all in the clear. They're holding out as long as they can to sandbag the Commonwealth once again. He wasn't even prepared to argue. They don't know what witnesses they're calling. They're all a mystery. They just want to have them. I mean, it's a miracle that these witnesses didn't come in, and it's like this is your life. Guess who this person is? Like in disguises into court. We're going to have the Commonwealth guess. Did you work on the SUV? Yes. I mean, what? It's so absurd. It's so grossly unjust to the Commonwealth, and has been let slide and let slide and let slide and all this nonsense, and never mind this very way too small an area, stay away area from the court so that the jury could hear the protesters from outside of court. I mean, no, the jury wasn't sequestered. And according to Ronnie, the juror, they talked about the case amongst themselves. They lied to the court. Nothing was done about that. Nothing has been done. And what's being done about the perjury? Daniel Wolf's perjury. There's a crime just being let it slide. So he perjured himself on the stand multiple times. Let it slide. And that's just a green light to all lawyers that they can do it too. In front of Judge Cannone, she lets a lot of stuff slide. Massachusetts, no one's going to come down on you. It's Massachusetts. Come on.
So you are muted. All right. Mr. Jackson, you're muted.
I don't know how I got muted. Yes, we are intending to call experts, and there are going to be experts that are in areas other than.
Did you just hear him? He said he didn't know he was muted. He didn't know how that happened. I've been on a lot of Zoom calls, a lot of work Zoom calls with lawyers. Never heard that happen before. He didn't know he was on mute. Give me a break. He's playing games.
DNA as well. But we haven't provided discovery because we don't even know what the 400 pages that or 500 pages that we just got 3 or 4 days ago include, nor the discovery that was handed to us this morning. As soon as the Commonwealth gets finished with their compliance obligations, we will comply with our discovery obligations. We have every intention of doing so, and we're fully prepared to do so. We're waiting on them.
Another lie. Another lie. Another lie to the court. They in fact continue to lie to the court and continue to hide their witnesses. We just met Dr. Russell. We can't do it. We've gotten too much stuff. We can't go through it. We haven't gone through it. We don't know who we're going to call 3 weeks ahead of trial. Give me a break. Judge Cannone, as a former defense lawyer, doesn't find anything odd with this? Really? And as a judge? Really? I don't mean to come down. It's Judge Cannone is just a tiny part of the problem. And I'm going to talk about the public also becoming part of the defense team. It's sometimes referred to as participatory defense. But they're getting their ideas from the public. And we'll talk a little bit more about that and Hank Brennan's new filing in a minute.
So once you get it from the Commonwealth, you can have it in a matter of a day or so, other than the DNA?
Well, I don't know if I can do it in a day, but once we have full
you do know, if you're calling witnesses, you know who you're calling, correct?
I have an idea who I'm calling, yes.
All right, and you've engaged experts, so you've been working with experts, so you should have all that information ready to disclose, correct?
We're in the process of getting those decisions finalized, yes, but some of them are going to be predicated on what the Commonwealth discovery and the totality of the Commonwealth discovery looks like. I mean, that's their obligation.
No, I understand. All right, but you will be
right. We don't know what's in these. Does this case involve an SUV? We don't know. Does it involve a car crash? We don't know who to call until we look at all the discovery. What nonsense!
Be calling witnesses, and you will be calling expert witnesses.
Absolutely.
All right. What is your estimate as to how long this case will take to try?
I assume if the Commonwealth case, I'm just throwing a dart at a dartboard, but based on what I know, if the Commonwealth case takes 3 to 4 weeks, I think our case would probably take 2 weeks.
Okay. All right. Mr. Lally, I suggest that you get that information as soon as possible. It could be that I strike it, but I would hear from the defense on that as well. But at least find out if they're able to do the testing.
Yeah, sure.
All right. All right. Thank you. You have your next date. We'll see you then.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Mr.
Oh, let me correct myself. Oh, I made an error. This was Alan Jackson. This is even worse. It was Alan Jackson who spoke to, not Yannetti. Excuse me. Alan Jackson who spoke to ARCA 4 days before, and he's saying he didn't know who to call. My apologies. He emailed Daniel Wolf from ARCA and mentioned an engagement letter and a retainment agreement. This is March 22nd, 2024. Thanks to Innocence Fraud Watch's ARCA timeline. I can correct myself. Thank you for making this. Alan Jackson spoke to ARCA witnesses Daniel Wolf on the phone and emailed him later on that same day. Below are some of Alan Jackson's statements from his email. Thank you so much for taking the time to get on the phone with me this morning. 4 days later, we don't know who we're going to call. What? Witnesses? We don't know. As soon as the Commonwealth, we don't know. We don't know what this case is about till we look at all the evidence they've handed us. Till we get their notice, we can't hand over anything, and we're not going to mention anyone that we're going to call, and we're going to hide our relationship all the way through the trial till after the hung jury, mistrial. Through the press, up to the moment we're caught, and then after that we're caught, we're going to still lie to the press, and then we're going to have a ridiculous, nonsensical story told by another lawyer, and I'm going to stay quiet. Alan Jackson spoke to ARCA witness. Thank you so much for taking the time to get on the phone with me this morning. This is his email, Alan Jackson to ARCA. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required. March 26th, so that was the hearing we just saw. Here's just an idea of the relationship between ARCA and the state. ARCA and the defense, excuse me. The 1st of May, 2024, ARCA witnesses were keeping track of their time for billing the defense. Here's the big problem that we misstated our case. Is the retainer and the keeping track of time. There's one of many problems with their new cover story that they just misworded it. ARCA witnesses were keeping track of their time for billing the defense, as noted by another phone call with Alan Jackson on this date. ARCA issued defense with a billing address on the May 5th. On the 5th of June, 2024, during a sidebar discussing scheduling and voir dire hearings, the defense stated, I provided everything we have. I can't make up discovery. I got a report, and everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows that they've got what I've got. Judge Cannone stated, I haven't. If you can't, that's fine. So not everybody knows, and I make those decisions. In response, the defense stated, certainly, you're the one who needs to know. And I thought you knew the federal authorities will not allow me to. So what happens when you break the law with the federal authorities? Nothing, I guess, in Massachusetts. And I thought you knew the federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report. He's got the report. That's it. I'm going to start asking questions on the report. That's it. He can cross on the report. Does anybody else see a pattern here? So very much like the hearing we just heard, we don't know who we're going to call, and we can't hand over discovery until they complete their discovery. And that's it. So they have everything that we have, and that's it. Almost like Alan Jackson's not just a defense attorney, he's also the judge. He's like bullying the judge. That's it. No more. And then the judge is pushing back. I make the decisions. And he says no. And then he pushes back again. Like, nope, that's it. That's all we have. Judge Cannone then says, so many don't know what they're going to testify to. The defense replied, yes, you do, because they're going to testify to the contents of the report, this vague report. The 9th of June, 2024, ARCA witnesses again spoke to Alan Jackson on the phone. On the 10th of June, 2024, referring to ARCA's report, Judge Cannone stated, I can't tell who does what or what the basis of the opinion is. David Yannetti stated to the court, these experts did not arise from us. These experts were hired by the federal government. This is after they have a retainer. And they provided a report to us pursuant to the TUI request, and it was specifically outlined and ruled that they could not prep with us for trial. Judge Cannone stated, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. Yannetti says, we have not been able to interview them regarding their findings, which are outlined in detail. You have not complied with your Rule 14 obligation, Judge Cannone says. David Yannetti says back, we can't, Your Honor, we can't. See, they're always stuck in these positions. We can't. The Commonwealth hasn't done it. We can't. We've gotten too much stuff. We can't. And then goes to the voir dire. Andrew Rentschler billed for the defense a round trip to Norfolk Superior Court and also separately for his testimony, 8 hours billed. Daniel Wilf billed for the defense 12 hours. On the 18th of June, 2024, Judge Cannone says, so the understanding of the voir dire is that this is for the Commonwealth's motion to exclude testimony. All right, that's what we're here for, the Rule 14 motion. Jackson stated, asked, is that the same with Dr. Wolf and Rentschler? And Cannone says, well, I thought that would help both of you. Someone states the Commonwealth has nothing on that. Judge Cannone says, you've been able to even talk to them. You haven't been able to talk to them at all about this case? Jackson says, that's correct. June 22nd, 2024, Daniel Wolf emails Alan Jackson and indicated what his response might be. He also included the following statement in the email. Feel free to make whatever changes you feel necessary. Prosecutor Hank Brennan pointed out during the February 25th, 2025 motion hearings that the margins of Daniel Wolf's outline included the following statements. If you don't want me to say this, that's fine. See, they said, well, he did talk about nighttime dealing with more what he says is statistically there's more accidents between pedestrians and vehicles that happen at night. But if you don't want me to say this, it's fine. But he said, I deal with more cases. So you don't know if that's just him as a person, the cases that have coincidentally landed on his desk had happened more at night. Very different than statistically there's more. And he didn't mention that. So one of their arguments was it was fine because he did mention it at night. It wasn't withheld, but it was statistically withheld from the prosecution. That would have been helpful to the prosecution. I mean, that's the idea of discovery. You hand over material that's helpful to, even if it's a bad fact for your side. You don't know what's going to be helpful for the defense, so you hand over everything. Not you statistically leave out things that would hurt you, that would be helpful to the prosecution, and hope that you get punished with a voir dire. Daniel Wolf provided Alan Jackson with an outline of questions and answers for his direct examination. His notes included suggestions of things to include and exclude from direct examination during his testimony. This included comments about concealing from the jury the fact that most pedestrian vehicles accidents occur at night. There was also reference to Daniel Wolf having misstated the number of times he had previously testified prior to Karen Reed's trial for her murder of John O'Keefe. That's something that you really need to have down. We've seen Michael Peterson's conviction for the murder of Kathleen Peterson totally overturned because of a misstatement of how many times they testified about a certain subject in trial. You should have that down cold if you're being paid, or even if you're being paid by anyone to testify, or if you're testifying as an expert witness in a trial, you should have that down cold. He knows that. Prosecutor Hank Brennan also stated the following during the February 25 motions. Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Rentschler on the 24th, round trip Norfolk, billed to the defense, all these billings, wait and travel times. Then there's expenses for testimony at trial on the 24th. Then there's expenses for the 18th and the 24th. $1,749, $1,932. So they are keeping very careful track of their time for the bill that they send. This is what Hank Brennan said. Within 1 month of the defense, with 1 month of the defense testifying, they get paid. Right, in July. So they gave testimony on June 24th, 2024. Andrew Rentschler gave testimony on behalf of the defense. And then his wife, Dana Wolf, joins the Free Karen Reed since June 24th, the day he testified. What a coinkydink. Andrew Rentschler billed the defense for further 5 hours, and Daniel Wolf billed them for further 6 hours. Oh, here they are walking into court. This is great. I'm sorry about the ads.
Hi, Karen. Oh, you're unbelievable.
That's them walking into trial. Unreal, right? And here they are, still images of Andrew Rentschler with the defense team on the day he testified. Then they invoiced the defense on the 12th. And then it was paid $23,925 was the invoice. Was paid by the defense on the 25th of July. And there's all the history of the TUI requests, meaning they were trying to get information from the feds. I mean, crazy. Crazy, crazy history. Funny Bunny, I think ARCA will decline coming back next trial. I hope so. I hope they're not allowed to testify. We're watching a massive fraud happen. And I feel like I'm the only one, screaming about it. I mean, this is the people of Massachusetts tax dollars, going into this trial for it to be just riddled with fraud from the defense. Manny says, I hope they also have dirt on the fake dog expert. I can open that up. I think the event will cause them to lose more supporters. I hope so. It doesn't seem like it. They seem to just all go quiet or buy it. But we know that dog expert, Marie Russell, was fake dog expert. That's a great phrase for her. Was a true crime fan. And I'm not sure if I'm buying her story of how she got in touch with the defense through John Lewin. It sounds like a cover story. I asked John Lewin about it and he was quiet. So I don't know. So John Lewin's a DA in California. He's known as King of the Cold Cases. I've interviewed him quite a few times. Interviewed him quite a few times and done many episodes with him on this channel. Tammie, knock knock, who's there? It's Alan and Karen. You ran to buy. You want to buy a raffle ticket? There's another thing. Thank you, Tammie, for reminding me. All their illegal raffles they've done. Alan Jackson raffled himself off. Certainly looks distasteful. I'm going to take a quick break. When we get back, how the defense in innocence fraud campaigns use crowds, use the public, become part of the defense. We'll talk about it in a second when I come back. Don't go anywhere. I'm going to be live tomorrow morning at 8:50. If this goes forward, I don't think it's going to be delayed, but we'll see. Don't miss it. Be back in a minute.
We don't take a break. Grab a snack or maybe a glass of wine. Roberta will be back in no time. This podcast is listener supported, so smash that like button and subscribe or become a patron for exclusive content if you are so inclined. Have something to say? Shoot Roberta a super chat. She will do her best to read it on air without delay. Now Roberta's back and ready to put the true back in true crime. Here's Roberta.
Was that a joke, Tammie? I can't even tell anymore. It's, did any news of any of these raffles come back to Judge Cannone? They were raffling off a seat in court at one point. I mean, what, it's like the Wild West, it's totally out of control. And I'm curious to see what happens tomorrow. Tomorrow, it seems like we might learn the fate. Alan Jackson might be thrown off the case. Yannetti might be thrown off the case. Elizabeth Little, Elizabeth Little, Alan Jackson, all working under Yannetti's law license, pro hoc vice. I don't know. They say vice, but I think it's vice. I think it's just so unnatural for American accent. Vice. It's kind of unnatural to say. But I just wanted to show you. So in this case, one of the things that you saw in the opening, after saying that they knew who did this, Karen Reed stood on the courthouse steps and said, "We know who did this. You all know who did this." Then Alan Jackson was asked, who did this? And he says, "We don't know." And Karen Reed says, "We don't know." All of a sudden they don't know, and it's not for us to know. When Aidan Carney had just written a blog saying, "We're not detectives. We're not meant to solve this." So they're getting ideas from the public. One of the things that Karen Reed supporters immediately said was, when Hank Brennan said it would have been nice to know that most accidents happen at night, shh, don't say anything. And Rentschler mentioned that most of the cases he deals with happen at night. It's not the same thing at all. They said, "Oh no, it was said." So it wasn't secret. When he says, "Shh, don't say anything" in the hearing, meaning it's secret. It wasn't secret. Then we see Alessi making the same argument in court. So they're using the public's ideas, and that is how innocence fraud works. They get ideas from the public. So it was really fun to see in this latest Commonwealth Notice of Discovery. We have the copy of the Massachusetts State Police report, copy of Trooper Tully's reports, copy of Dr. Crosby addendum's report, copy of a transcript of unredacted Gretchen Voss interview, another copy of an interview she did on July 13th, 2023, and one she did June 20, 20th, 2023, a copy of an email to Special Prosecutor Hank Brennan. So are this looks like members of the public telling Hank Brennan, hey, Hank Brennan, are you going to talk about the plumber that Karen Reed said she called that night? The reason she was delayed getting out to the bar the night she clipped John O'Keefe with her car. I mean, morning. It was done like, early morning time, just after midnight, midnight the next morning. But, if you consider it all part of that evening, she couldn't come out because of the plumber. John O'Keefe told Michael Camerano that he was upset that Karen Reed didn't ask him to help her with her rusty pipe issue, hot water issue. But look at all these copy of an email, where these people saying, hey, Hank Brennan. So if you have any ideas for Hank Brennan and you don't mind them being handed over to the defense, let them know. Are you going to talk about Karen Reed's behavior? And I have another quick thing to say about her behavior in a second. Copy and how it relates to the Adelson case in a second. Here is looking at these. This is copy of an email to Hank Brennan, email. And then there's police reports, and Canton Police Department report. So that was uplifting to see. I hope they're not all like crazy theories or, harassment or something else. But he says he hands everything over that he gets to the defense. But maybe he's getting ideas. Let's hope. Certainly the defense is getting ideas from the Free Karen readers who they've whipped up into a frenzy. But I wanted to show you, I've been talking about Donna Adelson, and I was really surprised when I first started talking about the Karen Reed case. And if you've been listening with me since the beginning, everyone was patient enough to help me we sort of learned about this case together on this channel. And I was always suspicious because I thought it was very weird that Karen Reed, before I really knew, didn't call off the dogs, meaning she didn't tell her supporters to not harass witnesses. And by not doing it, by not interfering, she's letting it happen and making it happen. Little did I know that she was spearheading that campaign, witness harassment campaign. And also that she never talked to the O'Keefes again. And and this is what Donna Adelson did. She also fled when they were coming for her phones, just like Donna fled when she knew the grand jury was about to indict her, fled to a non-extradition country, to Vietnam, one-way ticket. Now she says she was just clearing her head. But I found it really curious that Aidan Carney just recently referenced this case. So let me get this straight. Charlie and Donna Adelson conspired to have Dan Markell murdered in order to make sure that Wendy Adelson would get full custody of her kids. And Wendy had no idea they were doing this. This would leave Wendy's children without a father. And they didn't need to okay this move with her first. Of course not, right? This is always the point I make about the Adelson case, that no one would give the gift you can't return, you can't take back. Oh, you didn't want us? It was our gift. It was our surprise gift to you to have your ex-husband and father of your children, right, taken off the planet. Oh, you didn't brutally taken off the planet. Oh, you didn't want that? Oh boy. Well, that's disappointing, In their minds, Markel would be eliminated. Wendy would get the kids to herself, and these two would be sitting back silently thinking in their heads, "You're welcome, Wendy," knowing they would never be able to reveal to her the huge favor they had just done for her. Wendy Adelson is just much more attractive version of Jennifer McCabe. Now, I would say that Wendy Adelson and Donna Adelson are very much like Karen Reed, criminally minded. Just like Wendy Adelson never talked to the Markells again, changed the children's names from Markel to Adelson, is just like how Karen Reed never talked to the O'Keefe family after this happened and fled when she thought she thought her phone was going to be taken. She fled. And Donna, when she thought she was going to be indicted, fled. She also tried to set up the next guy she was seeing for her husband's, for her husband's murder. Just like Karen Reed is trying to set up a federal investigation on everybody who caught her, who had the goods on her. It's a much better. I thought it was curious because this is a true crime case that I think most people universally agree on. Although I was actually so pleased to see it. I did get 2 angry comments telling me I'm a horrible person, and that I'm on my Donna Adelson video, and then I'm probably the kind of person who gossips at Walmart and plays bingo. That was the worst put down they could think of, I guess. But I was pleased to see that someone holds a minority opinion on that case, in the Adelson case. It may be Harvey Adelson or someone who knows the Adelson family, but maybe just an onlooker who supports them. It's just, talk about minority opinion. People who don't think they're guilty. I was pleased to get it. So, it's just curious that he's trying to attach Karen Reed to to attach Jen McCabe to a much more hated and well-regarded, or two, much more hated and well-regarded as guilty figures. So that's what I have for today, guys. Please hit the thumbs up, share this episode. It really helps grow the channel if you share the episode. Help get the word out about innocence fraud. I will be back tomorrow at 8:50 a.m. in the morning for Karen Reed's hearing. Let's keep our fingers crossed that finally something happens. There are some consequences for all the fraud we're seeing in this case. Have a great night, everybody. Please support this channel on Patreon. Karen Reed is guilty t-shirts right under this video. Wear one with pride. I'll see you tomorrow at 8:50 a.m. Have a great night, everyone.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence from my clown.